Good morning. Today I am going to discuss with you a fantastic subject. And this judgment AR 2024 Supreme Court 1775. AR 2024 Supreme Court 1775 deals with offences punishable under section 67 and 67A and 80 Information Technology Act 2000. The problem is what was obscene and a sexually explicit content. This is the subject matter of the judgment. See, if you want to understand the procedures, formulas, you have to go through the entirety of the judgment. Practically, there are so many things I want to take your kind notice that so many words, procedures are being followed at so many places, even though we are in one union of India. First of all, one thing, the issue was college romance serial that was blamed for having committed offences under section 292, 294, 509, IPC 6767 of the Act. Initially, complaint was lodged, and thereafter that complaint, you see, was closed as action taken report on 9/4/2009. Here we say closer report, referred charge sheet, but here in Delhi they called it as action taken report. That is most important. Then so many judgments were referred, citing including Kushbu's comment of living in relationship and advising the woman to avoid pregnancy. All these things were discussed at so many pages. You can go through all those things. Then this is most important. In 2006, Information Technology Act was amended, and there on the strength of 50th Standing Committee report. That is most important. Then you see the definition of 292 IPC was discussed. Then this is most important. In K. Abbas versus Union of India, there were some tests and process to determine obscenity of one particular communication, book, video, whatever it may be. Then at paragraph 21, it is most important that the Bandit Queen film was testified, and several tests were applied. Number one, see, there was a 1991 guidelines for censor board certification and cinematograph 1952 to test. Then another thing, there is called Eklund test, Roth test, Miller test, Lemon test. These tests are being applied to decide the obscenity of any communication, publication, media, film, whatever it may be. So all these things you have to go through this by referring dictionary or by going the assistant of Google to understand what all are these. These are international tests. Roth, Miller, Lemon test. Lemon test is of America. Then Kushbu versus Kanyamal case was discussed. Radhakrishnan versus Union of India case was discussed. Finally, the entire subject was about the scale between the obscenity and non-obscene. So, whether the after applying the test, it is duty of the court to decide whether offence under section 67 and 67A would apply or not. Here, by considering all the facts, the Supreme Court held AR 2024 Supreme Court 1775 Apurva Arora versus another versus National Capital Territory of Delhi. So finally they caused the FIR. Before that some procedures are there, some challenges, argument, everything you may go through. But if you want to write an article, how to write an article means go through the judgment and download the other judgment, refer in this judgment, and cut which all are impressive wordings of the judges, and summarize that, give some title for every such contents. Then you overall consolidate all these about obscenity or what is the sexually exploiting or conduct in communicating, video, mass communication, whatever may be the title you choose. And finally try to give some advice to have check over all these issues and cite certain non-doctrinal research particulars about how the children are being engraved or incited commit other offences by looking the lascivious contents. So I hope you understand. This will be best judgment for such law students or those who are aspiring for High Court judges, wanted to write any article. You can very well do this way. You have to do the how to write an article. This is one of the very good judgment to write an article, and you have to select. You have to go through, perceive the contents of this judgment and the other referred judgment in this, and cut the important discussions available at various parts of the judgment in this referred judgment and the other judgments referred here, about 12 to 20 judgments were referred. I hope you understand. Best